The state is pleading with the Free State High Court not to discharge the accused in the 24.9 million rand Gupta-related trial. All the accused, except one, are calling for the court to discharge them from all charges. These include violating the Public Finance Management Act, fraud and money laundering. They argue the state has not proven its case. eNCA reporter Moloko Moloto was in court and filed this story.
The defense argues the state has failed to prove a 24.9 million rand payment by the Free State Agriculture Department to Nulane Investments was fraudulent and that it has no evidence of money laundering. The money was ultimately channeled to a company owned by the Guptas. All the accused, barring Dimakatso Morosi, now want to be discharged in terms of Section 174 of the Criminal Procedure Act. Morosi was head of the Provincial Agriculture Department when she allegedly approved the deviation from normal procurement processes in appointing Nulane Investments.
My lady, and as far as the gold-directed investigation is concerned, we saw that on a number of fronts. How the statements were taken, who commissioned the statements in violation of certain statutes, how witnesses were influenced. It's there, it's palpable, it must be telling. It rings in our ears. How can such a prosecution be fair? It cannot.
The commission of the crime of fraud, as far as accused number 1 is concerned, there's nil evidence. And if there's a nil evidence to that effect, accused number 1 is entitled to a discharge.
So the first break is, how would accused 7 or 8 know that the money had an unlawful source? We don't say it did, but if that part is proved by the state, which we don't say it was, then how would we know? And then there would be nothing to launder.
Despite the court finding some of its evidence to be inadmissible, the prosecution has effectively probed why Nulane Investments was awarded the 24.9 million rand contract if its owner Iqbal Sharma had no connections with senior department officials who now stand accused of fraud. It cited Section 217 of the Constitution, which says organs of state must procure goods and services through a system that's fair, equitable, transparent, competitive and cost-effective.
They did not apply for any tender in the department. In their own admission, they did not talk to anyone in the department, but they got 24.9 million. They were given a tender. Is that not a connection?
Sirunye argued the department could not justify awarding the contract to Nulane without issuing a tender because there was no emergency to justify deviation. He argued Nulane overcharged the department as it subcontracted consultancy firm Deloitte to do the due diligence on its behalf and paid it 1.5 million rand while it pocketed the rest. The state also sought to poke holes in the defense's argument that no money laundering existed.
That 24.9 million becomes proceeds of crime because it has been generated through fraud. And the moment it starts being paid to accused number 5's account, and number 5 starts transacting with that money, then you are committing money laundering.
Judgment in the Section 174 application will be handed down on 21 April. If it isn't granted, all the accused will be expected to close their cases before judgment is delivered. But if Section 174 is granted, this may have an impact on the pending 280 million rand Frieda Dairy criminal case, which is before another court, especially as that failed project was established after recommendations from the due diligence report by Nulane Investments, and some of those accused in the Frieda Dairy project case are also in the dock in the Nulane trial. Moloko Moloto, Bloemfontein.